Before I go, guys, let me tell you that what we learned in the last session. So we started the chapter of prospectus. First thing what we try to learn is like what is the definition of the prospectus. In the definition, we have learned that whether some simple documents are also termed as prospectus or not, and answer was yes if certain conditions are satisfied. Then we learned the two important concepts like what is shelf prospectus and what is red herring prospectus. And we try to learn the concepts in detail, right? So far section 31, section 2, subsection 70 and 32 is coming to the end now, right? Now let's move on to the another section, and that section is here, section 25. Section 25. Now, what do you mean by section? Just a second. All right. Now, this is what the chapter is: prospectus and the allotment of securities. 23 is done yesterday. Private placement, section 42. 25. Now 25, as you can check it out, it is written the document containing the offer of securities for the sale to be deemed the prospectus. Okay, now if I ask about the questions, what kind of questions they can ask in exam, right? So the first question what they can ask like this, that explain the provisions related to the offer document issued by issuing house to get companies security subscribed under offer for sale. Under offer for sale. I know once you read this question, it itself little bit challenging to interpret. There are so many technical words are used, right? But I would like to highlight the two technical words. Yeah, the same question they can ask in the other context also. They write down the short note on deemed prospectus. Deemed prospectus. And fourth, transactions not considered as offer for sale. So these three questions are possible out of these three. Now in exam they can ask either the straightforward as it is mentioned here, or they can ask like in the story form. ठीक है, चलो शुरू करते हैं कि exactly how the environments are drafted. So sometimes what happens, company wants to take some amount share capital from the public. Let's say its planning is just to go for the 100 crores. But achieving the 100 crores, it's not easy. As I told you yesterday, you need a lot of reputation, you need a lot of I would say credit in the minds of the people. Then people will give you. And guys, if you couldn't establish your credit worthiness properly, there are high chances that your public issue may get failed. You cannot achieve your minimum 90% or whatever is mentioned in the prospectus. So what is the best I would say the option at that moment? Some of you may be saying like you should go to underwriters, pay them commission and let them take the whole risk of the failure of the subscription. Second, you may suggest me, so why should we not go for this red herring prospectus? Let get known the price of the shares first. But what if you're expecting 350 and according to the survey it is coming just 150 or 180? That is something what called quite disappointing. Yes or no? So underwriting is not working for you, red herring is not working for you. So what another option you have? Look, I know deemed. No, देखो इसका logic बोलो. Look, whenever you're just putting your hat to the law like subject, I can see most of you have not got taught under me or not studied from me. तो whenever I'm pitching the law, मेरा एक ही स्टाइल होता है कि first of all I create the psychology, like the logic why this provision was needed to be made. ठीक है. So deemed prospectus तो ठीक है, लेकिन under what circumstances it comes to the picture. My simple logical question to you is like, suppose there is one concert of Arijit Singh. I think one of your favorite singers, जानते हो ना उसे? ठीक है. अरिजीत सिंह का ये वहाँ पे कॉन्सर्ट है और आपको उधर जाना है, but the problem is you don't have ticket. But you suddenly came to know that your friend has the contacts of the ticket distributor, pass distributor. So what you will do? You will contact your friend and you will help that by using your contact. Please help me to get at least one ticket here. Please. So here your friend is becoming your helper, and through him you will get the ticket and you will just enter. Or another example, your friend is the admin over there. He doesn't need any pass. So what you will call him? Hey भाई, मेरे को भी ले जाना यार. हम ऐसा कहते हैं ना, मेरे को भी साथ में ले जा यार. So what you are doing, like, even if you are not authorized, but still you will get access to that concert just through your friend because your friend had the access. Yes or no? So what I'm saying, that company wants 1,000 crores, but doesn't have good reputation in the market, and they have the solid doubt that if they go to the public, they may not get the same price value what they are expecting. So what they will do, they will find someone who is well reputed in the market. Let's say State Bank of India. They will contact the managers and say that let's have a deal. What I will do is, like, I will transfer all of my shares to you. So look what is happening over here. In this situation, this company will transfer all the shares to SBI first. Are you getting this point? And the deal is, guys, SBI has to issue these shares to whom? These shares to public. If I go directly, people may not trust on me, but what if SBI advertising on my behalf? What if SBI is advertising in my behalf? What your logic says, like, will I get some good momentum or not? State Bank of India itself is promoting through under it, like, and State Bank of India has, I would say, lakhs of customers contact. It is easy for it to reach them. So look at the two important tasks. First contract, company will transfer all the shares to SBI. SBI will slowly will start transferring this to public. This is how the money will be received. Again, guys, first of all, public will pay money to SBI and then SBI will give to company. Definitely SBI is playing a wonderful role over here, so it deserves to get some remuneration. So in the name of remuneration, either you can give the part of profit or you can give the part of commission. Depends on you. You can tell that 2% is yours, 3% is yours. Or you can say, I need 120. Over and above that, whatever money comes, SBI you keep. So let's say, guys, SBI issued it at 130. So 10 rupees difference will be kept by SBI. So depends upon the contract. Law is silent. Law is not saying anything on this. It is on you how you want to proceed. Here you tell me who is issuing the shares of the company to the public. I would like to give you the two options: intermediator or the company itself. Someone mediator. Yes or no? Guys, such mediators in the corporate law are known as issuing house. Issue houses. So role of State Bank of India over here is nothing but what? Issuing house. Issue house. Company is not issuing the shares. Somebody else on behalf of the company, by using its credit, issuing the shares to the public, soliciting the public. This transaction is known as offer for sale. Okay, this entire transaction, what you have learned right now, it is known as offer for sale. Okay. Pardon? If the company allows SBI to the share, then it's not offer for sale. No, it's not offer for sale. It is just a invitation. But this is called the offer for sale. offered for sale. Now, what's the problem is, see, definitely if SBI wants to impress the public, it must have to use some it must have to give some information about the company, how the company is, what was the company doing, what the company is doing, and what is the future plans of the company to do in the upcoming future. So definitely SBI will use some advertisement like documents to the public. Otherwise, something should be given. If today anyone is asking, okay, SBI, I am glad that you are issuing the shares of so and so company, but what is that company? I want to see its financials. I want to see its performances, foreign collaborators, investment in the foreign countries. So what happens is here, State Bank of India will issue one document to the public. And look, this document will be called anything, like it can be considered as the advertisement, or it can be considered as the offer document also. Okay, till this the story is clear. I am not going myself, but I am appointing somebody else, and that somebody else will advertise on my behalf. Based on that, the public will pay money to issue house, and issue house will give money to me. This is what the story is. My question is, assume that by mistake State Bank of India provided some false information in this advertisement, some wrong information in this offer document, and because of that some of the shareholders lost their money, and they filed a charge case on the company stating that the advertisement what you issued to us contained the wrongful information, misstatement, purposeful misstatement, which attracts the liability of section 34 and 35. Again, I want to remind you guys what is section 34 and 35. Look at this. 35 talks about criminal liability, 35 talks about civil liability. What is the difference between criminal and civil liability first? Criminal, I do not want to go much in detail, but try to understand. When I say about the criminal liability, it means penalty or jail. Civil means no penalty, no jail. Just you have to compensate the losses. So for example, you see in Indian Contract Act, guys, if you are breaching the contract, the law of this country will not put you behind the bars. The maximum punishment what can be given to you is like you have to compensate the party you have suffered the losses because of your breach. And that's the reason Indian Contract Act is one of the civil laws and not the criminal laws. I hope you understand. Right? So civil means you have to just compensate the losses what happened just because of your misbehavior, your misconduct, or the fraud what you have made just because of the misstatement in the prospectus.
But in section 447, it speaks about sending
to the jail.
fraud to jail.
Yesterday एक ऑब्जर्वेशन आपने नहीं किया शायद 447 में मैक्सिमम 10 इयर्स का इम्प्रिजनमेंट है, बट वो 447 कहाँ रेफर्ड है? 34 में 35 है, ये बताता हूँ. इट इज इन, बट व्हेन यू क्लिक ऑन 35, वेयर इज 447? एक रेफरेंस बता दो. So 447 reference is given in 35. That means criminal liability. The reference of 447, you see, you can't see any highlighted section here which is indicating 447. It can't, because 35 is for the compensation. Cost to customers, cost to investors, cost to creditors, cost to government authorities, any person. So now here your question should be, if you are putting something wrong in the prospectus, your liability is what, criminal or civil? I would say both. So not only you have to pay just the compensation to the people, but along with that, if the fraud got proved, you may go to the jail also. You may have to pay the fine also, penalty also. Am I clear to all of you? Okay? So guys, it is, I would say, concurrent. So 34 and 35, it is not like either or. Concurrent stands for together also it can apply and you have to pay, and that's, I think, the best justice, right? Is the logic clear? So something wrong is mentioned in this offer document and some of the members lost the money, and here the question comes like whether the company's directors or the State Bank of India's officers who were handling this entire issue are liable under section 34 and 35 or not. That is only simple question. Are they liable under section 34 and 35? So look, one of the arguments what the SBI officers or the company's directors may put, 447 is applicable. We agree if we have violated the terms according to 34 and 35. 34 and 35 deals with the civil and criminal liability if there is a material misstatement in the prospectus. Prospectus is something what is defined under section 2 subsection 70. Yesterday we did it, yes or no? Any document what is recognized as prospectus, it also includes the shell prospectus, red herring prospectus, any other document, circular, advertisement which is issued to invite the public to get the company's security subscribed for any, not a company, sorry, any body corporates. So issue of the prospectus should be done by the body corporate, but as you can check it over here, company which is one of the body corporates is not involved at all here. Involved नहीं है. There is no in fact any direct contact between the public and the company, and therefore this advertisement or offer document should not be considered as a prospectus because it is not matching the conditions of section 2 subsection 70. That was the one of the arguments in the past. So on what basis you are saying that this advertisement or the offer document is a prospectus? So if it is not a prospectus within the meaning of section 2 subsection 70, provisions of the prospectus chapters do not apply, and if they don't apply, you cannot impose as the liability also. And guys, government took very serious note on that, and they said this argument is not wrong. What is the formula to decide whether any document is a prospectus or not? Section 2 subsection 70. And government was forced to introduce one new concept which was beyond the definition, and that is section 25. They have said we agreed it is not a prospectus, but it will be assumed as prospectus. It will be deemed as prospectus. It will be considered as a prospectus. Do you understand? आ रहा है आप अपने डाउट रखिए, मैं उसी टाइप पे आ रहा हूँ. पहले मैं अपना एक क्लैरिटी करता हूँ. So even if these kinds of offer documents are not referred in section 2 subsection 70, still specially it will be considered as good as prospectus, not exactly prospectus, as good as prospectus. And it means all the provisions what are applicable to prospectus, the same would be applicable to here also, and therefore 34, 35, 447, congratulations, it is there. So guys, neither mediator nor company directors can provide the false information stating that we are not doing this. So lie to people, you can't do this. Same liability will be attracted. That is in nutshell the motive of section 25. Before I go to your doubts, my question number 1, is the concept of meaning of deemed prospectus is clear? Yes or no? Concept of offer for sale is clear? And sometimes why company goes for this kinds of contract, is it clear? If you are clear till this, I can step forward to the other exceptions. But before I go, yes sir, you had a doubt. Because these kinds of transactions by mistake, purposefully, intentionally, unintentionally, I don't know, while making the definition of the prospectus, this situation is not covered up there. You tell me which text of the definition affirms this situation as the prospectus.
They say any before any circular order by any body corporate. So this is also body corporate.
Body corporate which is issuing the security for own self. For own self. Not written. So you can not take any meaning. No? अब आप ये कह रहे हो कि ये नहीं लिखा है, ऐसा भी कहाँ लिखा है कि कोई और करे तो उसको माना जाएगा. दोनों तरीके से आर्ग्यूमेंट देखो. तो ज़्यादा जस्टिफाइबल आंसर क्या होनी चाहिए? अच्छा काम करो, आई एम रिलायंस इंडस्ट्रीज लिमिटेड, मेरे को पूछे बिना तूने एक एडवर्टाइजमेंट, आई एम रिलायंस इंडस्ट्रीज लिमिटेड, विदाउट आस्किंग मी यू इश्यूड वन एडवर्टाइजमेंट टू द पब्लिक एंड यू पुट एनी रैंडम फैक्ट्स ओवर देयर. इज कंपनी लायबल? That is the reason. That's what I'm saying. Later on, government realized their mistake. So you have two options as being the lawmaker. Either you amend section 2 subsection 70 or you make the special provision. You have these two strategies. Yes or no? But over here, what strategies they have implemented? Instead of amending section 2 subsection 70, let's create new section 25, and that's what they have done. So ultimately, it is a prospectus. It is a prospectus. All the provisions of the prospectus will be as it is applicable, but under deemed prospectus. Separate provision, not under section 2 subsection 70. So ultimately, your object or my object was what? Like ultimately, the wrongdoer should not get escaped from the liability. That's what 25 provides.
So if this company was not aware that they did this, then it is not going to be a deal breaker.
Look, if company has provided the correct data, but mistake is done,
So company doesn't know that if somebody is doing this on its
then company is not liable. According to the principle of natural justice, guys, you can't be punished if you are innocent. Seriously, what? Because punishment, penalty, jail is there if you are doing something wrong. And in order to do something wrong, you should have the intentions to do something wrong. If you do not know, then if you could prove this in the court, nothing will happen. In fact, while you are driving a car at the speed of 60 kilometers on highway, which is acceptable, and suddenly somebody comes from the wrong side and hits you and he died on the spot, are you guilty for the charges of murder? It is just the accident. And let me tell you guys, you will be acquitted, released on the spot because it was his mistake. Why is coming from the wrong side when it's a highway? Person got killed, I'm telling you. कुछ नहीं होगा आपको क्योंकि आपकी bad intentions नहीं थे. Make sense? Okay. Now when the point comes, later on the corporate lawmakers discovered one problem in this model. I'm giving you one more model over here and you just try to compare this. Okay? There is one company. Company has already issued the shares, let's say to me. Okay? And the total share value is 10 crores. Now I need funds. I need funds. It is unlisted company. So in order to get the funds, what I have done is like, look, if it is unlisted company, that means stock market like facilities are not available. Stock market facilities available only for the listed entities, not for the unlisted one. So if I want to sell these shares, what I have to do? I have to myself get the valuation of the shares by consulting some good chartered accountant who has the valuation rights. After getting the valuation per price, I have to find the buyers. What is the best way to find the buyers? I have to advertise in the newspaper, providing the details of the company, providing the performance of the company, providing and justifying that why this price is good price. That also I have to mention. So guys, what is happening? Just to sell these shares to somebody, I will go for one advertisement here, and then assume that I found some buyer. Let's say here, Mr. Sunil Amlani is the buyer of this 10 crore rupees shares. When I issued this advertisement, my question is, you tell me, but it is open for everyone? It is open for everyone, or it is only for the specific entity? For everyone. My question to you, the advertisement what I have issued, it is not a prospectus. I know that because company is not issuing it. Somebody else is doing this. But my question to you, is it deemed prospectus under section 25? Is it deemed prospectus under section 25? Okay, let's try to compare this. In these two models, company similarities. Company allotted the shares to here SBI. Company allotted the shares to Mr. Chirag. Similar. SBI further sold the shares to public. Chirag is also trying to sell the same shares to public. This is what the similarities between the first example and the second example, right? My question to you is like, if the first example, this advertisement what was issued by the middle one, is deemed prospectus under section 25. So that is what the question here is. This advertisement what is issued by just like a middleman, me. Why, whether it is deemed prospectus or not under section 25? बस इतना सा सवाल. It's not. Reason क्या है? Reason.
Sir, because before the company wants to issue the company.
Wants to issue. Here company doesn't want to issue. That's what you're saying.
No, it's like for the issue to the public, that's why it went to issue. Here it did not do it for that.
So maybe you are trying to say the purposes of the both the transactions are different
Yeah.
as far as the company's objects are concerned.
Yeah,
Okay.
evidence CH.
So and moreover, it's not the issues, CH.
Okay.
There it's advocates SBI, so it can be considered as
अरे
a.
अरे अब भी बदल देते बेटा. CH चिराग is not. अरे कितनी देर लगती है बेटा. I love complex questions. चलो अब बताओ.
So it's things are completely different in both.
ज़्यादा कमीशन लो. नो. ठीक है. देखो आप है ना यही चीज़ है बेटा. जब भी आप प्रोविजन पढ़ो तो उसकी गहराई समझिए सबसे पहले. आप जानते हैं कानून का हर प्रोविजन एक स्पेसिफिक प्रॉब्लम इंडिकेट करता है और उस प्रॉब्लम के कुछ सर्कमस्टेंसेस होते हैं. यकीन मानिए बेटा कानून की पढ़ाई में लॉ की पढ़ाई में जब तक उस सर्कमस्टेंसेस को नहीं जानोगे आप जो रीड मार रहे हो ना तो दिमाग में नहीं जाएगा. डेप्थ ही नहीं आएगी. डेप्थ होनी चाहिए. 14 घंटे पढ़ना इंपॉर्टेंट नहीं है. 2 घंटे पढ़ो प्रॉब्लम नहीं है लेकिन ऐसा पढ़ो कि उसका आगे पीछे सब पता चल जाना चाहिए. इनफैक्ट यू कैन प्रिडिक्ट द नेक्स्ट मूव ऑफ द गवर्नमेंट. Okay, I don't want to go in that much professional discussion. Fine. Let me tell you guys what is the fundamental difference between the first example and the second example. In the first example, SBI is working as the agent of the company. It is not doing for itself. It is whatever SBI is doing it is doing for the company's interest and not for its personal interest. That is the first difference. So I can say the State Bank of India is issuing these shares on behalf of company and not for itself. Let me sum up whatever arguments you have given, okay, in just one sentence. But in the second example, if you see Kotak Mahindra Bank, which was the genuine buyer, just like you and me. So first of all, Kotak Mahindra Bank applied to IPO of the company. So already company went for the public issue. In that public issue, Kotak was the subscriber, and it got allotted with the 10 crore rupees shares. And now if Kotak wants to sell to CS Sunil, it is not for the company's sake, it is for its personal sake. So whatever profit comes, Kotak itself will hold it. So let me tell you guys, technically, this is nothing but the contract of sale according to the Sales of Goods Act 1913. Because shares and stocks are the part of goods. Section 2, subsection 7. अगर याद हो तो. But this is offer for sale. Why? Because here intermediate issue house, it's not a, I would say, independent entity. It is doing something for the sake of fees, for the sake of commission. He had raised a wonderful point, sir, whether Kotak is charging something for that. Okay? Now, this is crystal clear, but the point is, my dear student, you tell me guys, over here this advertisement is deemed prospectus, but over here advertisement is not deemed prospectus because it is not backed by the company. It is not supported by the company. Yes or no? So in first example, if you are putting some wrong information, the government will not spare you and you have to pay a lot of penalties. And you may go to the jail also for that. But in the advertisement, what others are putting about the company's least bothered. So in second example, guys, if the advertisement contains some wrongful information, company's officers are not liable because company is not involved at all in this.
Sir, in the second example, Kotak Mahindra is further selling it to CSU, right? Firstly, it purchases from the company. And then it further sells.
Yeah, it is just like a resale process. You bought the goods and it is just like a resale process. You bought the goods and then you forward it.
But first example, SBI is the mediator
Rather, I would say use the word representative or agent.
for the company.
Exactly. In fact, did you observe one thing? When the shares in this example, 1,000 crore rupees shares got transferred to SBI, company didn't ask for the money on the spot. Company didn't ask for the money on the spot. What they say? You start selling it, collect the money, and from the collected proceeds you start paying me.
So that's the issue of selling.
That is offer for sale over here.
No, sir, SBI is the issue of selling.
Issue house, yes, that's what. SBI over here is the issue house. In this example, Kotak Mahindra is nothing but what? Independent entity. So guys, issue house, I think the point what sir has raised, I want to tell you. When I speak about the word issue house, it's not necessarily to be company all the times or the bank all the times. Even proper writer could get the license from the SEBI can become what? Issue houses. So please, we are not going in that detail. Otherwise, Section 25 also says that while company is having the contract with issue house, who will sign the contract? If there's a proprietary concern, who will sign? If there's a partnership firm, who will sign? If there's a body corporate, who will sign? But that is very technical and procedural aspect, nothing to do with your existing one. So I do not want to teach this. In case for the sake of knowledge, if you want to, books is yours. Open करो पढ़ो उसको कोई बात नहीं. अब चलो थोड़ा डिस्कशन मेरे हिसाब से लंबा हो गया भाई. Problem क्या है इसमें? Entire in this entire story, what I have said, what is the problem? Let me tell you what is the problem. You know that first example carries a lot of responsibilities, but the second example, no responsibilities. So in order to get escape from the responsibility, what company and reputed like this SBI can deal, instead of treating this contract as offer for sale, in the contract itself they will put the heading contract of sale, contract of, they will officially pretend like this, that company is the seller of the shares, SBI is the buyer of the sale, and whatever SBI is selling further to the public, it is resale. By just having one small document adjustment, can you make government officers, CBI officers fool or not? Because now here you have got the freedom to mention any rubbish. And let's say CBI caught you under the charges of fraud. They say, hey, excuse me, so how can you do that? If they go to the company and said, company kya bolega? Sorry sir, I sold the shares to SBI, and what SBI does for its purpose, I don't care. Government तो बेवकूफ है भाई, उसको तो कुछ पता नहीं चलता. हमसे भी ज्यादा स्मार्ट लोग बैठे हैं बेटा जो लॉ बनाते हैं, IAS ऑफिसर्स, IRS ऑफिसर्स. वो पागल नहीं है, उनको पता है कि ये पॉइंट आएगा. यू टेल मी हाउ मच टाइम इट टेक्स टू टर्न ऑफर फॉर सेल टू सेल. यू क्या करना है, दोनों बिठा के कागज साइन कर लो, खत्म. इट इज नॉट ऑफर फॉर सेल, इट इज जस्ट अ सेल, खत्म, बात हो गई. ऐसे लॉ कहता है अभी हवा निकालते हैं, एंड दैट दे केम अप विथ द पॉइंट्स. देखो the question what I did ask like over here, that transactions which are not considered offer for sale, that's what now I'm going to teach. Basically, if it is the genuine sale, what is its feature, what are its features, what is its quality. The guys of समझो, if I am the company and I'm just selling my shares, I'm issuing my shares to the genuine investors who bought the shares from the company. First feature is payment is on the spot. पेमेंट इज नॉट पुट ऑन होल्ड. अरे हाँ है ना बेटा, इन द स्टॉक मार्केट क्रेडिट चलता है नहीं, पेमेंट साइकिल चलता है, बट वहां पे पेमेंट ऑन द स्पॉट करना पड़ेगा. अरे हाँ है ना. हाँ, यू कैन टेक अ लोन फॉर दैट, यू कैन जस्ट यूज द ओवरड्राफ्ट फॉर दैट, यू कैन ऑल्सो स्वाइप अ क्रेडिट कार्ड फॉर दैट. बट यू टेल द कंपनी, सर आई यू गिव मी द शेयर्स फर्स्ट, इन द नेक्स्ट मंथ आई विल गिव यू मनी. ऐसा नहीं चलता. So first feature, that most of the times when the company and other parties coming into the contract of the share capital, payment is instantly paid, it is not put on hold. And second is, guys, generally the shares what I am giving to my genuine investors, he keep for the long time. Immediately he doesn't sell, because immediately when you sell that things, it is termed as nothing but speculation. Yes or no? So based on these two, beta, again please understand, based on these two facts, that generally people who are genuinely subscribing to the shares, they find these two patterns over there. Pattern number one, payment is immediately. Second pattern is they are just keeping this for the long time, at least for 6 months, 7 months, 8 months. Yes or no? So based on that, they have drafted one assumption, but वो assumption काफी जबरदस्त है. If government officers are reading SBI and otherwise a company, they will scrutinize first of all books of accounts. And from the books of accounts, if these facts are appeared, what kinds of facts are appeared? That payment is not made immediately. Shares are transferred. Look at here. Company has transferred all the shares to SBI, but payment abhi nahi hua. Payment is coming gradually. The officers have reason to believe it is not sale but offer for sale. Even if in the contract it is sale, they don't care. So guys, these right they have given, the law has given under section 25 that don't consider the contract. When you find the fact number one, कौन सा? Shares are allotted but the payment अभी तक नहीं आया, क्या assume कर लेना है? Offer for sale. And if the company say no, no sir, it is not offer for sale, it is sale, let the company prove in the court. So burden of proof that this is not offer for sale, it is sale, and the advertisement is not a document deemed prospectus, that burden is not on the government, it is shifted on the company. Let them shout a lot in the court, and let them get relied upon the court. Now what court's judgment? But prima facie, initially, this transaction will be referred as offer for sale. I hope you are understanding. What if payment is immediate? So law says if you find the second condition over there from the scrutinizing the records, that after transferring or allotting the shares, this issue house has transferred the same shares to the public immediately within 6 months. How much? Within the span of 6 months. Then it is highly doubtful that this settlement between the company and issue house is nothing but what? Offer for sale. So either of these two situations, when you find from the scrutinizing or examining the books of accounts, payment is not paid immediately, or shares are transferred within the span of 6 months, it is offer for sale. And if company wants to challenge it, let it be, go to the court, that's all. But am I clear? So this is the entire explanation about section 25. Okay? Yes sir.
So what if the issuer pays everything right now, and then after 7 months, 8 months, it's sellable?
Then I would say government will be at the back foot if they consider this as the offer for sale, because that assumptions now government cannot use. So here government needs to prove that it was offer for sale, or the person who is challenging needs to prove it was offer for sale, and this is deemed prospectus. But still CBI officers has the right to consider this as what? Offer for sale, depends upon their findings. But बात ये होगी, if it is based on those two conditions, burden of proof gets shifted to the company's shoulder. But if otherwise, then allegations, the person who is alleging needs to prove it was offer for sale. Make sense or not? ठीक है बच्चों. तो now let's quickly go for the section 25. तो यहाँ पे क्या लिखा है बच्चों? Look, lot of contents are there, but I'm just reading for the sake of your convenience. So where a company allots or agrees to allot any securities of the company with a view to all or any of those securities being offered for sale to the public, but offered for sale. So either all the shares they want to go for offer for sale or any part. Any document by which the offer for sale to the public is made shall for all the purpose be deemed to be a prospectus. Now what is offer for sale transaction? I think everyone who is sitting in this class knows this now, yes? And all the enactments and the rules of the law as to the contents of the prospectus and the liability shall as it is applied to deemed prospectus. That's what this sentence is trying to say. देखो लिखा, shall apply with the modification and also shall have the effect accordingly, as if the securities had been offered to the public for subscription, and as if the person accepting the offer in respect of any securities were subscribers for those securities, but without prejudice to the liability, if any of the persons by whom the offer is made in respect of misstatements contained in the document or otherwise in respect thereof. I know a lot of things you are, sir, ये क्या language है? छोड़ो, सीधी बात ये कह रहे हैं, anyone who is making the offer for sale on behalf of the company shall be liable. And this issue, indirect issue, will be termed as good as the public issue by the company. Am I clear to all of you? Good. For the purpose of this act, it shall, unless the contrary is proved, be evidence. Hey guys, they are talking about the evidence. So from the books of accounts, if these two situations are detected, those two situations will become the evidence that this is not a sale, but it is what? Okay. That an allotment of or agreement to allot securities was made with a view to the securities being offered for sale. Point number one, that an offer of the securities or any of them for the sale to the public was made within what time? अरे बोलो भाई, So I gave to SBI and SBI allotted the shares to public within what span? Guys, this is indication that it is offer for sale. That the date when the offer was made, the whole of the consideration to be received by the company in respect of the securities had not been received by it. In genuine public issue, what comes first, money or allotment? कल ही तो मैंने पढ़ाया था, एप्लीकेशन के साथ ही पैसा आ जाता है भाई, अलॉटमेंट तो बाद में होगा ना. तो पहले पैसे आते हैं या पहले अलॉटमेंट होता है? बट ऑफर फॉर सेल में फर्स्ट अलॉटमेंट टू SBI and then slowly money is coming.
Sir, the allotment is made to SBI and voting power is the SBI or company?
Whosoever is member, he must have to enjoy the voting power. On the records, look, I would say when you read the section 2 subsection 55, the definition of the member, it just says that if you are a member, you do have the voting power. Member means the man or the person who is mentioned in the register of the membership.
Unless they get the money, they will become member.
ऐसा कहीं पे नहीं लिखा, ऐसा कहीं पे नहीं लिखा. हाँ, कोई प्रॉमिस कर सकता है. देयर कैन बी द शेयर्स अलॉटमेंट बेस्ड ऑन व्हाट? क्रेडिट पीरियड. बट मनी लेटर और सूनर सपोज टू बी रिसीव्ड, एंड इफ इट इज नॉट रिसीव्ड, ऑडिटर ऑफ द कंपनी अंडर सेक्शन 143 नीड टू रिपोर्ट. वो तो ऑडिट में पड़ा होगा that whether money for the subscription is received or not, and if the money is not received, what otherwise then this is received by the company. अरे भाई प्लीज यार, ऐसा कहीं ना कहीं तो पढ़ा होगा आप लोगों ने. 143 पढ़ लेना, पता चल जाएगा.
अगर in case the intermediary is not able to meet that 90% application.
That's a wonderful question. Guys, you listen. Section 25 clearly says that for all the purposes, this deemed prospectus shall be considered as what? Public issue. Just like IPO or FPO. So all the provisions of IPO, FPO as it is applicable here also. So 90% subscription is compulsory, and if you couldn't achieve this, you know what will happen.
So then it will lead to
You have to refund this. No option. No option. Look guys, go to the language only. In interpretation of statutes, I will teach कि इसको कैसे करना है हमको, ठीक है? Okay, till this everyone is clear. So this is what I wanted to discuss about section 25. ठीक है? So as you say language, ये language भाई कौन लिखेगा? मैं भी नहीं लिख पाऊंगा अगर बात है तो देखो भाई, जब language की बात आती है, don't cross the boundaries of the interpretations. ठीक है? उसके लिए notes वगैरह आपको बनानी है अपने हिसाब से, तो बनाते रहना यहाँ पे. Okay बच्चों, after that I would like to go to the contents of 26. Now 26, section 26 has, I would say, the two versions. Version number 1, company's own version, and second is the SEBI's version. In Companies Act 2013, I think I should start the discussion with this. If the company issues the shares, suppose, what is the minimum subscription?
90%.
Very good. Very good. Wonderful.
application.
90%. Since I think your first PU, you are listening this, right? 90% minimum subscription, 90%. But let's say in CA Inter, I'm asking you this question, that what is the minimum subscription as per the Companies Act 2013? What should we answer? What is minimum subscription according to the Companies Act 2013? What should we answer? Still 90%? तो 1 रुपये भी अगर एक्सेप्ट किया तो मिनिमम नहीं है वहां पे कुछ. अच्छा, हाउ मेनी परसेंटेजेस आर गिवन? आपने तो पढ़ा होगा, बताइए. हाउ मेनी परसेंटेजेस आर गिवन इन द कंपनीज एक्ट 2013? 90, 80, 85, 70. चलो इनमें से कोई सिलेक्ट करो. नहीं पढ़ा ऐसा? नो इश्यू. Okay, let me tell you Gucci. While you read the chapter of allotment of shares, there is one section called section 39. आइए आपके सामने रख देते हैं अभी. देखो मजा आएगा इसमें. When you go to section 39 and when you read the first subsection 1, क्या लिखा है? No allotment of any securities of a company offered to the public for the subscription shall be made unless the amount stated in the prospectus as the minimum amount has been subscribed. तो भाई यहाँ पे कोई नंबर तो लिखा नहीं है. So according to section 39 subsection 1, whatever amount you are mentioning in the prospectus, that will be your minimum subscription.
So then you have to.
That's what 10% mention कर लो. If I mention just the 10% in the prospectus and I received it, my simple question to you, section 39 subsection 1, complied or not complied? भाई मेरा सिंपल सा सवाल समझ लो. अरे यार बंद कर दे इसको इधर ला, साइलेंट करके छोड़ देते यार. Sorry बेटा for the disturbance. यहाँ पे I'll bring it to 1:30. Thank you. All right. Am I clear?
Yes.
ठीक है. If I just mention 10%, am I complying with section 39 subsection 1 or not? तो कंपनी एक्ट में बेटा 90% नंबर है ही नहीं. तो ये कहाँ पे? इट इज अंडर सेबी गाइडलाइंस, सेबी रेगुलेशंस. तो ये मुझे बात बताओ गाइस, एज बीइंग द कॉर्पोरेट ऑर्गेनाइजेशन, विच एक्ट यू वुड लव टू फॉलो, 39 और सेबी? ₹1 दिखा दो. You can, आपके एक शेयर ₹10, ₹10 फेस वैल्यू, दैट इज माय मिनिमम सब्सक्रिप्शन. मैटर ओवर. नो लेट मी टेल यू व्हाई दिस ब्लंडर. इतना बड़ा ब्लंडर लॉ में कैसे आ सकता है? हाँ मैं इसको ब्लंडर मानता हूँ. और देखो भाई ऐसा मत माना कि लॉ में ब्लंडर्स नहीं होते. यू वोंट बिलीव, आई प्रेडिक्टेड सर्टेन थिंग्स इन दिस क्लासरूम एंड आफ्टर 2 years माय प्रेडिक्शन टर्न्स टू प्रोविजन. ऐसा हुआ है. फाउंडेशन में सेक्शन 3 कैपिटल ए है. कौन बताओ वो क्या है? सेक्शन 3 कैपिटल ए क्या है बताओ? Okay, have you been explained like this that if the number of members, let's say 7 right now in public company, anyhow gets reduced to 5 or 4, company gives how many months?
6 months.
6 months to correct the mistake. And if within 6 months you couldn't,
He'll be liable.
then after 6 months whatever new liabilities are there, existing members are liable who knows about the fact. All those who do not know are not liable. ऐसा provision है?
As
The same provision was there in the Companies Act 1956 as section 45. Same. जानते हो what mistake is done? Central government forgot to repeat the provision in the new act. अच्छा मेरे पास प्रूफ है, मैं कोई बात ऐसे नहीं करता. ठीक है, प्रूफ है भाई. क्या लिखा है? 3 कैपिटल है बेटा. इट इज सेट इन बिटवीन 3 and 4. You see the date of introduction. 1st April 2014 was the date when it came to charge. और इसकी नोटिफिकेशन डेट कौन सी है? Guys, this got amended in 2017 और 2018 में इसको 3 और 4 के बीच में डाल दिया गया. Now point was, still the problem is there na. So during you understand, I would say 14, 15, 16, 17. If the number of members are getting reduced below 7, क्या ट्रीटमेंट है? नो आंसर. तो मैं और उस वक्त मैं बच्चों को बोलता था कि नया एक्ट साइलेंट है, लेकिन आज नहीं तो कल उनको अपनी गलती 2014 में मैंने जो भविष्यवाणी की थी वो 2018 में सक्सेस हुई. तो देखो, इफ यू स्टार्ट गोइंग इन डेप्थ, यू स्टार्ट रियलाइजिंग दैट what is perfect, what's not perfect, what is good, what's not bad. So that happens. Okay? That happens. So guys, it's a blunder. Why? Look, in 1956 it's fine. In the 1956, I'm telling you, according to 1956, companies which are going for the public issue can be categorized into the 2 parts. Again, I want to repeat, guys. Come on, speak with me. Companies which are going for the public money can be categorized into 2 parts. Company which wants to go to the stock market, which doesn't want to go for the stock market. So even if you are accepting the money from the public, It was optional whether you go to listed or you do not go for the listing. Now guys, as far as the SEBI regulations are concerned, it is applicable only for the listed company and not for the unlisted company. आपको ऐसा समझ में नहीं आया? रिलायंस जियो का नाम सुना है भाई? कितना के पास उसका सिम कार्ड है रेजिडेंस? जियो का फोन किसके पास? जियो सिम किसके पास है? तो बताओ भाई. हाँ. What is the current stock market price of Reliance Jio? 2500 or something like. पागल आप कह ही नहीं सकते because Reliance Jio is not listed. आप Reliance Jio Infocom Limited की बात कर रहे हो. You can't get its stock market price. Reason is it is not listed in any stock market. There's whatever, I think almost around more than 60,000 crores it has arranged on its own. Private placement से वो सारा पैसा उन्होंने paid up किया. Not by going to the members even, like not by giving to the public. Are you getting my point? So earlier in the 1956 there was an option that as being the people who is getting the money from the public, why you have two options. Either you go for listing, your choice, you do not go for the listing. So you understand, if you are not going for listing, SEBI guidelines don't apply. Then what to apply? Company Act applies. Have you ever been confused? There is a question in accounting, मुझे आज भी पता है, what is the minimum application money a company should receive? 20 गलत है. 25? How many of you are confused between 5% and 25%? Because in some books it was 5%. How many of you have come across with this two number? But application money, when I talk about the application money, कुछ किताब में, कुछ बुक्स में 5% लिखा है, and in some books 25%. जिनका स्टडी अच्छा, I know that you all are good, don't try to think wrong. तो डेप्थ में पढ़ते तो ये आपको डिफरेंस पता चलेगा. 5 versus 25, what is the true data? Because 5 means out of 10 rupees face value, I can demand just of 0.5 as application money. But if it is 25%, minimum I have to call is the 2.5 rupees per share. तो 0.5 या 2.5 rupees भाई कौन सा सही है? दोनों सही है. Because 5% is mentioned. 5% is mentioned over here in 39. But hi, I would say यहाँ पे नंबर दिया हुआ है. The amount payable in application money on every security shall not be less than. I didn't expect कि यार prospectus पे मैं allotment भी पढ़ा दूंगा. पर ठीक है, sections का खेल चल रहा है तो समझ लो. तो ये 5% भाई यहाँ से आया है, तो you now must know 25 कहाँ से आया होगा. तो अभी आप कंफ्यूज हो गए क्योंकि अगर 5% डाला तो SEBI वायलेट हो जाएगा. So guys, this confusion was not there in the previous company law, because people who were going to the public invitation had the two options: either go to stock exchange, you do not go to stock exchange; go to listing, otherwise you do not go. If you are not going, SEBI doesn't apply. So which provisions needs to be applied, guys? Again, I would say company law. So for them, minimum subscription was something what is mentioned in the prospectus, and in fact I would say they had the right to change the minimum subscription at any point of time. Put 10%, 15%, 20, 80, आपके ऊपर है. But if you are going to the listing, guys, central government's provisions will be put aside. That means Company Act will be put aside. और कौन सा लागू हो जाएगा? So guys, listed company as far as the contradiction between the Companies Act and the SEBI, Company Act will get defeated and SEBI will win. I hope you understand this.
So because the special act is always preferred over the.
That is what. That I think all of you, I think that I don't need to tell. इस स्टेज में उतना तो पता होना चाहिए आप लोगों को. Special always presides over general. मजे की बात ये नहीं बेटा, क्लाइमेक्स तो अब आने वाला है. According to the Companies Act 2013, all those companies which are going for public invitation, it is compulsory to get listed in the stock exchange. So guys, अब आप समझो, public invitation is equal to listing. So technically guys, section 39 subsection 1 and 2, अब उसका कोई मतलब ही नहीं रहता भाई. क्यों? Public invitation is equal to listing. Listing means अभी सेबी में 90 लिखा, तो ये इसका भी क्या जरूरत है इसके? हाँ, in future the central government gives some exemptions to certain class of companies that even without going to the stock exchange you can demand public invitation. Then guys, these provisions will be applicable. तो today 5% and this minimum in the prospectus, ये कोई applicable ही नहीं होने वाला भाई. अब सीधा 90% और 25 लग जाएगा. So that was the explanation. देखो मैं ये कहना चाहता, law makes the blunder. So now subsection 1 and 2 are just like nothing but a decoration piece. That's all. Yes, sir.
Can you give an example where you don't have to get listed when you do?
I don't have, sir. Right now, I don't. In my career, I have not seen anything that you're going to the public and you need to list. Because आप समझो बच्चा, अरे भाई चलो मैं आपको थोड़ा कंपनी लॉ ही है, लेकिन देखो मेरे को डाउट अच्छे आ रहे हैं, लेकिन देखो इस डिस्कशन की वजह से आई वांट टू टेल यू थोड़ी डिस्कशन स्लो हो जाएगी, पिचिंग स्लो हो जाएगी. आर यू फाइन विद दैट? Law needs to be changed frequently according to the circumstances and the bugs what we find in the law. How many of you know the holding subsidiary company concept? I'll come to your point. रुको. Holding subsidiary company का जो concept है वो किसको पता है? वो section 19 है, उसकी बात मैं नहीं कर रहा हूँ. Once one company controls the other company, controller is holding, and subsidiary is what? Today one company can own maximum layers of how many subsidiaries? Layer की बात कर रहा हूँ बेटा. Maximum layers of subsidiary owned by the holding company. Come on. ये पढ़ाया होगा आप लोगों को. आपके नीचे आप कितनी सब्सिडरीज को ले सकते हो? आंसर इज 2 माय डियर स्टूडेंट्स. कितनी है? अब ये बात ध्यान रखो, अगर आप टुडे देखेंगे लेयर्स ऑफ subsidiaries, there should not be any additional layer of the subsidiaries if the company reduces. No, not like that. Wait. No company can have more than 2 layers of the subsidiaries as per the state rules. The relationship between any 2 layers of the companies is based on the control, and control is defined under section 2, subsection 27. अब लेयर की इंटरप्रिटेशन क्या है बच्चा? Clueless. But recently they have introduced the subsidiary rules, and over that they have provided in detail what do you mean by layers. लेयर के 2 मीनिंग होते हैं, वर्टिकल एंड हॉरिजॉन्टल. तो किसके बारे में बात हो रही है? Let's say I am a company, I have these many subsidiaries. According to the law, it's valid or not. ठीक है? A limited, B limited, C limited, D limited. I have 100 subsidiaries under me in horizontal line. Is it violation of the law? So you meant to say the limit is there, but only for the vertical. That's what you are trying to say. Okay, now assume I have A limited. A limited is the holding of B limited. B limited is the holding of C limited. C limited is the holding of E allowed. Exactly. So you try to understand, whenever I talk about the layers, it's not horizontal, it's always vertical. So A has B limited and B has C, that's all, except wholly owned subsidiaries. मेरा सवाल ये है ही नहीं. मेरा सवाल ये है कि लॉ को ये क्यों लाना पड़ा? लॉ में 2 लेयर्स दिया है, क्या हो अगर मैं 3-4 लेयर डाल दूं? लॉजिक क्या है उसके पीछे? इन सर का जो आंसर है ना, वो जनरली अब देखो भाई मैं इतने डीप में नहीं जाता हूँ, लेकिन अब आप मुझे प्रोफेशनली बोल रहे हो कि जानना है, तो थोड़ा हम जाएंगे. आपके सवाल पे मैं आऊँगा, रुकिए. देखो सीधी सी बात है, if I have black money and I want to launder this, as being the consultant and the chartered accountant, मेरा पहला ट्राई ये रहेगा, in case my money is got caught by any government agencies, उसको इतना कंफ्यूज कर दो कि ढूंढ ही ना पाए कि सोर्स ऑफ मनी क्या था. ऐसा ही करोगे ना आप? इनकम टैक्स ईडी को इतना घुमाओ कि वो कंफ्यूज हो जाए कि असली इस मनी का ओनर कौन है. तो ए लिमिटेड इन्वेस्टेड इन बी लिमिटेड, बी लिमिटेड इन्वेस्टेड इन सी लिमिटेड, सी ने डी में किया. आप ऐसी मल्टीपल लेयर्स क्रिएट कर दो. बीच में से मान लीजिए कि देयर इज द लेयर ऑफ 58, वहां से पकड़ा, ये पैसे कहाँ से आए पता नहीं सर, किसी शेयर होल्डर ने डाला। कौन है तेरा शेयर होल्डर? अरे सर वो कंपनी है। अब कंपनी के पास कहाँ पैसा आया? सर हमको हमारे शेयर होल्डर्स ने दिए। हाउ विल यू फिगर इट आउट दैट हु इज द रूट?
Sir, is this case about corporate venture?
अरे भाई, फॉर द कॉर्पोरेट वेल यू शुड फाइंड द फेस फर्स्ट। Culprit, wrongdoer is liable. Who is the wrongdoer? I know you. What is arrest or investigation? I'm not saying it's impossible. Did you see the level of difficulty? ऑफिसर के पसीने निकल जाएंगे ढूंढते ढूंढते यार, सालों साल तक इन्वेस्टिगेशन चलेगा, कुछ हाथ में नहीं आएगा। Guys, in UPA government, Congress government, there was no any restriction. बेटा ये जो 2 लेयर का कॉन्सेप्ट है ना, मोदी साहब लेके आए हैं। अब उन्होंने क्या किया? योर इन्वेस्टमेंट टू योर सब्सिडरी फाइन, योर सब्सिडीज इन्वेस्टमेंट टू हिज सब्सिडरी फाइन, आफ्टर देन नॉट अलाउड। तो ये मोटिव होता है, आप समझो। डू यू नो गाइस, दिस प्रोविजन इज रेसेंबलिंग टू सेक्शन 186 ऑल्सो। वो आपके फाइनल में आता था। इन्वेस्टमेंट कंपनी, आई एम द इन्वेस्टमेंट कंपनी, आई डोंट हैव अ सब्सिडरी, but I can invest just in my one company, and that one company can go for just one more company. So one vertical layer wise maximum 2 entities are allowed. उसके बाद 186 prohibit करता है आपको, even if it is no holding subsidiary relationship. हाँ, horizontally you go for unlimited, उसमें कोई प्रॉब्लम नहीं है, क्योंकि you are at the second layer. I can detect the first layer. अब समझो, you are at this layer. Who is your boss? I know the answer. I know the answer that all these rays are coming from which sun. But there are layers of the layers, guys. How would I figure it out? Now the first doubt I'm coming to the picture here. But इसके बारे में जो होल्डिंग वाला कॉन्सेप्ट है, उसके कोई डाउट्स मैं एंटरटेन नहीं करूँगा। देखो, आपको बता दो, बट मैं प्रोस्पेक्टस पढ़ा रहा हूँ, तो हो सके हम अपनी जो डिस्कशन उसकी कन्फाइन या लिमिट में रखेंगे। उन्होंने एक डाउट पूछा, डू यू हैव एनी एग्जाम्पल सर, फिर कंपनी गॉन फॉर इश्यू बट couldn't get registered into stock exchange? मेरे पास नहीं है बेटा। मेरे एक्सपीरियंस में ना तो मैंने ऐसा देखा है और ना मैंने ऐसा पढ़ा है। बट आई कैन टेल यू द लॉजिक बिहाइंड व्हाई इट वाज नीडेड टू मेक इट कंपलसरी। मुझे एक बात बताओ भाई, यू ऑल ऑफ यू अंडरस्टैंड इकोनॉमिक्स? डिमांड एंड सप्लाई की बात होती है। यू आर द शेयर होल्डर ऑफ वन अनलिस्टेड कंपनी। अज्यूम रिलायंस जियो की बात करें, रिलायंस जियो Infocom is unlisted company. You have 10 crore rupees shares. You want to get your sister married and you need the funds. You want to sell this. How will you sell this? What are the challenges you are going to face there? Huh? You no need, brother. It's your assets. मैंने ऐसे प्राइवेट शब्द देखो, ये एक रिक्वेस्ट है मेरी आपसे। अगर लॉ कुछ नहीं कहता, फैकल्टी कुछ नहीं बोला, तो मेहरबानी करके अपने खुद से अजम्पशन मत ले लीजिए। आप जो बोल रहे हो वो सही है। अगर आप पब्लिक से पैसे नहीं लिए तो ये कंपनी प्राइवेट बन जाएगी, ये प्राइवेट प्लेसमेंट बन जाएगा। अब समझो, और प्राइवेट कंपनी में भी कहाँ लिखा है कि शेयर्स बेचने के लिए मेंबर्स की परमिशन चाहिए? क्योंकि आप जो बोल रहे हो क्लियर कट वायोलेशन ऑफ सेक्शन 58 है। तो अगर कहीं पे लिखा नहीं है तो आप ये अज्यूम मत करो, ये कानून है, आप समझो, लॉ है। बेटा लॉ में मैं बच्चों को, यू नो दिस, लाइक इनको बोलो, हर क्लास में बोलता हूँ, वट एवर यू नो फॉरगेट इट, बिकॉज द जनरल लाइफ, डे टू डे लाइफ प्रिंसिपल डोंट अप्लाई इन द लॉ। लॉ की अपनी खुद की लैंग्वेज होती है, खुद के पैरामीटर्स होते हैं, ओन डेफिनेशंस। तो वो मत कीजिएगा, मेरी रिक्वेस्ट है आपसे, वो मत कीजिएगा। एम आई क्लियर? तो किसी मेंबर की, भाई एक बात समझो, कैसा ट्रांसफर होता है शेयर्स का? डाउनलोड वन फॉर्म कॉल्ड द शेयर ट्रांसफर फॉर्म, get the sign of transfer, get the shares of transfer, submit to company, Company will take your old certificates, will strike them off, and will give the new certificates in the name of the new transferring. ऐसे होता है, कहाँ consent आई? और every day, let's say there are 10 share transfer. You have to take the logically में आपको होता है कि how you should critically evaluate your statements. जब हम किसी को डाउट आता है, every day 10 share transfers are taking place. If you say this statement is correct, members consent is needed, but a members consent can be obtained only in the general meeting. अच्छा, तो every day आप वो हजारों लोगों को इकट्ठा करोगे? नहीं, वो पार्टनरशिप अलग चीज है. हम एक चीज समझ रहे हैं, मान लो there is unlisted company but having 5,000 members, so every time do I need to call the general meeting? Doesn't make sense. And why are you asking any random guy? So and so shareholder wants to sell his shares. Do you agree? उसको क्यों पूछ रहे हो? उसकी एसेट से उसके पैसे, उसको बेच रहे, खत्म है बात को. हाँ, सामने बायर होना चाहिए, दैट्स ऑल. हम दूसरों को क्यों पूछे? तो ऐसे थिंक लाइक अ लॉ मेकर, तो आपको सारे लॉजिक्स धीरे धीरे समझ में आ जाना चाहिए. ठीक है, और ये अच्छा डाउट था. तो बात समझो गाइस, वन ऑफ द बिगेस्ट प्रॉब्लम इज स्ट्रगलिंग टू गेट द बायर. I'm telling you the two examples. You have a car, suppose. You are giving to the shop owner who is in the business of the resale car, I would say old cars, and you are trying on your own, where there are high chances to get the buyers. When you give your car on brokerage to the person who is very damn good expert in the second hand car, or when you are trying on your own. आप होंगे नहीं सर, ट्राई टू ओन योर ओन, लेट्स गो टू OLX. बट OLX में क्या है? वो भी तो मार्केट ही है. तो गाइस, अगर आपको इजी बायर चाहिए तो एक मार्केट में रजिस्टर्ड होना कंपलसरी है. अरे हाँ है ना? चलो, इवन इफ यू फाउंड द बायर, अनदर बिगेस्ट प्रॉब्लम इज एट व्हाट वैल्यू यू विल सेल दिस. वैसे नो सर, यू सेल 10 crore. दैट 10 crore वैल्यू इज अकॉर्डिंग टू मी, not according to you. And guys, I want to warn you, the shares are not listed in the stock market, so demand supply की वजह से प्राइस नहीं तय होती वहां. जानते हो उस केस में CA हायर करना पड़ेगा और वो अलग से वैल्यूएशन सर्टिफिकेट देगा. प्रो रेटा वो अलॉटमेंट के टाइम पे है, लेकिन व्हाट्स द प्रूफ दैट the share price what you taken at that moment would remain constant all the years? I think day by day it changes. So every time when every seller wants to sell the shares, he must have to hire the valuer. Every time, I'm saying what? Every time, individually. So there are 10 buyers, 10 valuation reports, 10 prices. Isn't it problematic? So if you have private placement and private members, government doesn't have any problem because large amount of public is not affected. But what if guys you're going for 20,000 crore rupees IPO and almost 10,000 members or applicants have applied to that, and you are telling them we will not give you the facility of the market. So if you want to sell your shares, die. Find your own buyers, find your own valuation. Company will not help you. Welcome in company. Shareholders. As been government, ये सही पॉलिसी है. गवर्नमेंट मीन्स जस्ट ट्राई टू पुट योरसेल्फ एज अ लॉ मेकर. क्या ये सही है? नहीं भाई, बहुत बुरा है. तब जाके अक्ल आई और 2013 में बोला अगर पब्लिक के पास जाओगे, पब्लिक सबसे ऊपर है भाई, सरकार से भी ऊपर है, उनको हम निराश नहीं कर सकते. यू हैव टू कंपल्सरी प्रोवाइड द फैसिलिटी ऑफ द मार्केट एंड दैट्स व्हाई द लिस्टिंग इज कंपल्सरी. So now, since when, because I passed my CA final in 2012, 2011, November 11 was my exam, January 12 was the result. तो 2012 से मैं प्रैक्टिस कर रहा हूँ और एक साल के बाद तो 13 आ गया. तो मेरे पास ऐसी कोई कंपनी की इन्फॉर्मेशन नहीं है भाई जो पब्लिक में गया हो लेकिन लिस्टेड नहीं हो, और जो लिस्टेड नहीं होती उसके चर्चे भी कम होते हैं. आसपास कितनी प्राइवेट कंपनीज होगी आपको नहीं पता, क्योंकि वो बाजार में लिस्टेड नहीं है, तो उसकी डिस्कशन भी कम होती है. तो आई एम सॉरी, आई कांट गिव दैट इन्फॉर्मेशन. इफ यू वांट टू नो, गो टू गूगल. ठीक है. सॉरी आई हैव टेकन सम टाइम, लेकिन मुझे लगा कि थोड़ा सी प्रोविजन नहीं, थोड़ा बैकग्राउंड का सीन भी पढ़ना चाहिए, हालांकि इट इज़ नॉट एप्लीकेबल फॉर योर एग्जाम, इट इज़ जस्ट सेक ऑफ योर नॉलेज। ठीक है।
So, if I issue a prospectus to more than 200 people and anyone can apply, then listing is compulsory.
यस,
ये तो listing करना पड़ेगा
करना ही पड़ेगा।
पब्लिक को।
एक साल में है, लेकिन ध्यान रखो एक साल में है। सो अगर अभी 190 किया, नेक्स्ट ईयर 190, देन नॉट एन इशू। अब जो उसका सीए तय करे। नहीं किया तो अज्यूम कर रहा है, मैंने अभी तेरे को बताया। तेरे को कैसे पता उसके मेंबर्स 200 से ज्यादा है? यस, जस्ट ओनली 15। उसके टोटल शेयर होल्डर्स जियो के 15-20 से ज्यादा नहीं। गूगल, फेसबुक ने उनका स्टेक है वहां पर कुछ परसेंटेज में, ज्यादा मुकेश भाई और उनकी फैमिली का पैसा है उसमें। तो वही मैं आपने अज्यूम कैसे, क्या कोई एविडेंस है आपके पास? नहीं है तो मत करो भाई, वो नहीं है 200। और दूसरी बात, अगर 200 से ज्यादा है, पहले साल 150, दूसरे साल 150, तीसरे साल और 150, कहाँ वायोलेट होता है लोग? चलो। और भाई रिलायंस में 100 भी नहीं है, आप समझ लो, 100 भी नहीं है शेयर होल्डर्स। वापस छोड़िए। नाउ द रीजन बिहाइंड, देखो बच्चा 39 में थोड़ा समझा दिया है, ठीक है, 40 थोड़ा समझा दिया, सेक्शन 40 ऑल्सो। Once you go for the public invitation, your securities must be dealt in the recognized stock exchange, one or more recognized stock exchange. So guys, anyone who issues the prospectus, is it compulsory for them to apply for the stock exchange or not? Prospectus is equal to public invitation. Public invitation is equal to compulsory listing. Compulsory listing means you have to apply for stock exchange. CA Inter, I think 2018 का क्वेश्चन है, डिस्कस करूं। Company went for a prospectus issue, public invitation of some amount. It applied for 3 stock exchanges. 2 approved, 1 rejected. Can company keep the money? Can company keep the money? बेटा ये क्वेश्चन मेरी नहीं है, ये कहाँ की क्वेश्चन है? सी इंटर में ऑलरेडी पूछी हुई क्वेश्चन है। कुछ ब्रेक लेना है थोड़ा सा, नाश्ता पानी है सब कुछ। इस क्वेश्चन के बाद हाँ इसका डाउट है।
What is the point of listing on many stock exchanges?
देखो राइट नाउ द थिंग्स आर इन इलेक्ट्रॉनिक फॉर्म। थिंक अबाउट 80s, थिंक अबाउट 90s। वहाँ पे बेंगलोर का स्टॉक एक्सचेंज मैन्युअल था, बॉम्बे स्टॉक एक्सचेंज मैन्युअल था। इफ यू वांट टू सेल योर शेयर्स, सपोज, विल यू मूव फ्रॉम बेंगलोर टू देयर? डिफिकल्ट है थोड़ा सा। बात ये, अगर आपके शेयर स्टॉक एक्सचेंज में लिस्टेड है तो पॉइंट ये थोड़ा स्ट्रेटेजिकल हो सकता है, सो दैट यू कैन गेट द डबल फैसिलिटीज। ये सीधी सी बात समझ के, यू हैव बॉट वन टी शर्ट फ्रॉम द मैक्स शोरूम, बट उनका ये कहना है कि इंडिया के किसी भी शोरूम में तो उसको एक्सचेंज कर सकते हैं। हाँ ये पॉलिसी है उनके पास, इट इज नॉट लाइक। मैक्स शोरूम के बारे में जानते हैं, जो कपड़े बेचता है, तूने वहां से टी शर्ट लिया, ठीक है, तेरे को बदलनी है विद इन 7 days, तो तू इंडिया के किसी भी मैक्स शोरूम में जाके उसको बदल सकता है। ऐसा नहीं कि तुझे को यहाँ पे आना है। तो मोर मार्केट्स मीन्स मोर फैसिलिटीज, यही होगा। अब वो कंपनी की सोच पे, ठीक है, क्या होना चाहिए उस हिसाब से। इस क्वेश्चन को आंसर दे दो बच्चा, क्या है? So once you issue the prospectus, it is compulsory to apply for at least 1 stock exchange. But company is very much, I would say, generous. It wanted to give the multiple facilities to its investors. So instead of 1, they got the securities listed into 3. But out of these 3, 1 rejected the application. When you issue the prospectus, guys, is it compulsory to mention the names of the stock exchanges where the securities will be traded? Do you need to mention or not?
Yes, sir.
Otherwise, how would the people come to know that where I will sell and buy? So it is mandatory, all the applications what you have made to the stock exchanges. Am I clear? Isn't it a contract? Isn't it a condition? agreement provided by the company to the member stating that I will give you the facility of the 3 stock exchanges. But now because of some reason you cannot give the 3 facilities, you can give just only 2 facilities. Isn't it breach of agreement? It is just like this. I'm telling you I will give you the 5 facilities, but after taking the money I say, no sir, I will give just the 3. 2 are not possible. How will you feel? Do you have right to cancel the contract or not? And guys, don't you think this will lead to a lot of litigations in the court? तो लॉ ने यहाँ पर स्टैंड ले लिया. लॉ ने क्या कहा? If you are mentioning 1, you have to get the approval of 1. Mentioning 2, it is mandatory to get the approval of 2. So whatever number you are mentioning, it is mandatory to get the approval from all. Any one rejection, refund the money. Even if it is 100% subscription. In fact, I can ask you the question. Tell me the circumstances where even if the subscription is 100%, but still company needs to refund the amount. So you learned. First one. If you failed to get registered under any of the stock exchanges where you applied, but the provision what I have discussed, it is section 40. अरे यार ये तो शेयर कैपिटल में पढ़ाना था मुझे अभी, लेकिन ठीक है. आई एम ग्लैड. देखिए कम लोग होते हैं तो इंटरेक्शन ज़्यादा होता है, मज़ा आता है. ठीक है. सो नेवर थिंक लाइक दिस. चलो सर टाइम पास के एक पॉइंट में क्या है, कुछ टाइम पास नहीं, काफ़ी वैल्यूबल था. थोड़ा ब्रेक लेंगे बच्चों, थोड़ा चाय पानी नाश्ता करके आओ. रिमाइंड मी आफ्टर दिस